Good morning, Justice Makgoka.
Good morning, Chief Justice.
How are you this morning?
I am well, Chief Justice. Are you well?
I'm well too. I'm well too, and all the commissioners are well.
Thank you.
Thank you very much. Let me begin by thanking you for availing yourself as a candidate for the Constitutional Court vacancy, as well as availing yourself for this interview. We appreciate it very much.
Thanks, Chief Justice.
I'm not going to explain certain ground rules because you are not appearing here for the first time. You have appeared for High Court, you have appeared for Supreme Court of Appeal before. Is that correct?
That's correct, Chief Justice.
Yes. The only difference is that since you appeared for appointment to the Supreme Court of Appeal, is that we have adopted selection criteria that guide us in the selection of candidates. And in all our questions, we will be seeking to get information from you that will assist us to see how you meet those criteria. You understand?
I do, Chief Justice.
Thank you very much. I'm not going to go through your academic qualifications. You do have BProc and LLB. You are a candidate for LLM.
I must correct that, Chief Justice. I'm a student for LLM. I understand there is a
difference.
A difference, yes.
Yeah.
Yes, I'm a student, yes.
Maybe it's a difference without distinction without a difference. But I think everyone understood when it says candidate that you mean you are busy with your LLM.
Yes.
Yeah.
You have to reach a particular threshold
to be a candidate.
To qualify as a candidate.
Oh, okay. You must have completed the papers.
Yes.
Yeah, okay, all right. I don't think anybody will take that against you. And you did articles in the early 90s and you were admitted as an attorney in the mid 90s. And you practiced as an attorney for many years. And you were appointed as a judge of the North Gauteng High Court. Is that correct?
That's correct, Chief Justice.
All of that is correct that I've said. Yeah?
Yes, Chief Justice.
Yes. How many years did you sit as a High Court judge before you went to the Supreme Court of Appeal?
8 years, Chief Justice.
8 years. And during that period, you wrote a number of judgments which were reported. Is that correct?
That's correct, Chief Justice.
Yes. And you have now been in the Supreme Court of Appeal for how long? It
will be 6 years. I was interviewed exactly on this date in 2018, and I was appointed with effect from the 1st of June.
Yes. Okay. Or exactly on this date?
Exactly on this day, yes.
Oh, that's interesting.
Which happens to be my daughter's birthday.
Yeah. And in the Supreme Court of Appeal, you have also produced a number of judgments that have been reported, some of which have been regarded as very important. Is that right?
That's correct, Chief Justice.
Yes. You have had the opportunity of acting in the Constitutional Court for 2 terms. Is that correct?
That's correct, Chief Justice.
Please share with the commissioners your experience of the work of the Constitutional Court and how you found your acting stint to be.
Thanks, Chief Justice. Firstly, it was a privilege to be asked to act in the Constitutional Court. I found the work to be intellectually stimulating. It was a rewarding experience for me. But the sheer volume of work, I had thought that having sat in Gauteng, nothing could faze me. But I was just surprised by the sheer volume of work in the Constitutional Court. But the the collegiality is something to write home about. The scholarship and the intellectual rigor that goes into the judgments of the Constitutional Court is everything to be expected from an apex court in any country. Thanks, Chief Justice.
No, thank you very much. You have included in the questionnaire some judgments or some cases, you have referred to some cases where you wrote judgments that you regard as very important. Obviously, we have had a chance to read those, but I will ask you to say a few words about a few of them. Do you want to say something about the Clicks judgment, which appears at page 10 of your bundle, that was later confirmed by the Constitutional Court?
Yes, Chief Justice, thank you. The Clicks judgment, it was a minority judgment in the Supreme Court of Appeal. I took a view that the matter concerned a constitutional issue regarding Section 27. Obviously, there are business interests implicated in that matter, but I took a view that it implicated a constitutional right enshrined in Section 27. That was the starting point in my judgment. And as we know, ultimately, the majority of the Constitutional Court upheld my minority judgment. And it is important because it involved community pharmacies. Had the Constitutional Court ruled in favor of Clicks, it would have had devastating effect on a number of community pharmacies across the country.
Yes. Do you want to spell out that detrimental effect it would have had?
The effect it would have had is, had Clicks been successful, it had the effect that Clicks could manufacture medicine and sell it. So a Clicks outlet in a particular area could sort of emasculate the little community pharmacies in a particular area.
So in a way, that would have been anti-competitive, which might not necessarily be in the competition law sense, but
yes,
basically, realistically, that what it would squeeze out
yes,
small competitors.
Exactly, Chief Justice.
Yes. And PAF versus SCH, it's a judgment that you refer to. Do you want to say something? Because Professor Bradley, you point out, Bradley Smith has described that judgment of yours as groundbreaking.
Yes, Chief Justice.
That's on page 11 of the bundle.
Yes. That judgment concerned the hiding of assets in a trust by a husband during a divorce case. And we had to, in a way, pierce through the veil of a trust. And we looked at the jurisprudence of our court, the Supreme Court of Appeal, especially the case of Badenhorst versus Badenhorst. And we came to the conclusion that the circumstances of the case called upon the court to pierce through the trust veil, to come to the assistance of the wife, because otherwise she would have been stripped of what she would have been entitled to.
Yes. And do you want to say something about, I see that you have done one on environmental law, Harmony Gold. Do you want to tell the commissioners why that judgment is important?
Harmony Gold concerned, excuse me, Chief Justice, concerned the duty of mining companies to treat the polluted water as a result of their mining activities. So in this instance, a company having done mining activities and having polluted water in a particular area sold the mine to another company and said, we are divested of any responsibility to clean up the water resources. I disagreed. I said, well, that obligation continues to follow you, irrespective of the fact that you might have sold your company and mining operations to another company. The Supreme Court of Appeal agreed with me and upheld my judgment.
Yes. Now, you have also produced judgments during your acting stint in the Constitutional Court, is that right?
That's correct, Chief Justice.
Yes. Do you want to talk about the importance of two of those judgments?
Chief Justice,
Any two?
well, I've produced two judgments in the Constitutional Court, Ole Sitze versus Minister of Police, and the Casino Association versus the MEC in Northwest. Ole Sitze concerned the development of the common law by the Supreme Court of Appeal, unwittingly so. It concerned whether the principle of once and for all is applicable to two causes of action. You would recall that, Chief Justice, both the High Court and the Supreme Court of Appeal said, well, you should have, Mrs. Ole Sitze should have combined her actions in one. So she couldn't separate the two. That is the action for unlawful arrest and the action for unlawful detention. And as a result, they said, both courts said, she couldn't divide the two actions because they arose from the same set of facts. And we disagreed with that approach because we said these are distinct causes of action and each one of them has got its own requisites and it can be brought separately from the other. And we said to the extent that both the High Court and the Supreme Court of Appeal had approached the matter in the manner they did, they developed the common law, but without complying with the Constitution. Chief Justice, you would recall that you preferred a linear route in that matter. But yes, that's where we arrived at. And the casino matter involved levies that were imposed by the MEC on the Casino Association and the members of that association, I think Sun City and another company. And we decided that those levies were effectively tax. And we said, well, you can't, as a legislature, as the executive, impose tax without the intervention of the legislature. So that is why we ultimately declared those levies unlawful and ordered the MEC to repay part of the levies that had been paid pursuant to the regulation that was in issue.
Thank you very much. You have had an opportunity to sit in matters where orders of constitutional invalidity have been made. When you deal with a matter sitting in the Constitutional Court where there is a constitutional challenge in terms of legislation, once you have concluded that an order of invalidity should be made, constitutional invalidity in relation to legislation, what are the immediate issues that should come to your mind that you should also address in the remedy? What are the issues that should immediately come to your mind to say, I will have to deal with this and that as well?
Yes. Chief Justice, we are guided in that regard by Section 172. So the starting point would be 1721, in terms of which you would have declared legislation to be inconsistent with the Constitution. And then you go to B. B gives you sort of remedies. What do? You would start to think of retrospective effect of the declaration, or you might want to think about suspending the declaration and giving an interim order. There are various other concepts that come into consideration, like reading in. The court might read in certain words into the statute to make it constitutionally compliant. For example, you might, in the National Coalition for Gay and Lesbian case, you'd add a word into a statute and say, this statute must contain this particular word. You might also want to sever certain words from legislation, which makes that legislation to be unconstitutional. Severance basically means you take out words, you scratch out words and say this word is out because its presence makes this legislation to be unconstitutional, so you sever it. You have both actual severance and notional severance. Actual severance is actually what it says. You sever words and say these words are out. Notional severance is just to limit the effect. For example, in I think Ferreira versus Levin, where it concerned the Section 4172 of the Companies Act, where it says, if you give evidence at an inquiry into companies' affairs, that evidence can be used against you in subsequent proceedings. It might be criminal proceedings. So the court notionally severed that and said, well, to the extent that you would be required to sort of implicate yourself, to that extent, it is unconstitutional. Chief Justice, you might also want to employ an interpretative mechanism called read down. Read down is not really a remedy, but it's a mandatory interpretative exercise that the court must undertake to make sure that a constitutional provision, a legislative provision that is unconstitutional can be interpreted in such a manner that it does not limit a right.
Well, so a reading down will not come in if you have concluded that the statute is invalid. It comes in while you are interpreting to
Yes.
see, to make sure that the statute is read in a way that is consistent with the Constitution.
That's correct, Chief Justice. As was done in cases like Hyundai and recently, I think, in Makate.
Well, you have answered a question that I was going to come to also on severance. You have already dealt with it. And reading in and reading down, you have dealt with. What can you tell us about the principle of subsidiarity?
Well, the principle is this. If the Constitution makes provision for a right, a litigant, let me rephrase. If the Constitution makes provision for a right and legislation is enacted to give effect to that constitutional provision, a litigant cannot approach the court to rely directly on the constitutional provision, but must rely on the legislation that has been enacted to give effect to that right. Unless, of course, the allegation is the legislation itself does not adequately protect that right. For example, Section 33 of the Constitution makes provision for just administrative action, and it commands that national legislation should be enacted to give effect to that right. That legislation is PAJA. So a litigant cannot override PAJA and rely directly on Section 33 of the Constitution.
Thank you. Section 1771 of the Constitution provides 3 grounds for the removal of a judge from office. 2 of those grounds are gross incompetence and gross misconduct, which suggests that if a judge is incompetent or if a judge is guilty of misconduct, which does not amount to gross incompetence, which does not amount to gross misconduct, that's not a ground to remove them. That might sound odd. What do you think is the constitutional significance of these provisions of Section 771, which say you can only remove a judge for incompetence if it's gross incompetence, for misconduct if it is gross misconduct?
For me, Chief Justice, it goes to A, the tenure of judges, tenure and security of judges, and B, the independence of the judiciary. I think it was deliberate that the framers of the Constitution put the threshold that high, that a judge should not be easily removed from office. To remove a judge from office, it must be because of gross incompetence or gross misconduct. I think it was deliberate that the threshold is that high to protect the independence of the judiciary, that judges should not be afraid to make mistakes which can be maliciously be used to remove them from office. So it is about security of tenure. It is about the independence of the judiciary.
Thank you very much. I will now allow the minister if he has got any questions.
Yeah, thank you very much, CJ, and good morning, Judge Makgoka.
Good morning, Minister.
You will be pleased to know that I see that you're a lecturer at the PLT, that I'm one of your students.
Yes, I think together with former minister, I can't remember, but yeah, former minister of communication.
Yeah,
Miss
so-
Faith Mutambi, I think. Yeah.
Yeah, so I'm glad that today the roles have reversed. I'll be assessing you.
Yeah. That's fine.
But I hope that the minister is not going to think this is an opportunity to get marks.
Yes.
I just want us to traverse a bit what you dealt with the CJ on the clicks matter.
Yes.
What is of interest to me is that while this you dealt with this matter in terms of the regulations, the Pharmacy Act 53 of 1974 and the Constitution,
Yes.
while when you look at it, it has the characteristics of competition law or anti-competitive conduct or behavior. What I want to find from you, I mean, with the Competition Act, there is a process of inquiry by the Competition Commission, which will obviously help the tribunal, the appeals court, and also when it comes up, it has benefited from all those processes. How did you arrive at this conclusion, which has been obviously confirmed by the Concord, which shows that it was a right kind of conclusion without these earlier inquiries that have been put in place in terms of the competition law?
Yes, Minister. As I said, my starting point was Section 27 of the Constitution. That was my starting point, and it influenced everything that I said in that judgment. You would note that in the judgment, I didn't concentrate on any antitrust considerations. I did not go there. I just said, well, let's look at the aim of the regulation, and let's look at what the Constitution says.
How do you think this could also impact other judges or courts dealing with almost similar matters? Because, I mean, what is in the Pharmacy Act, you may find it in other statutes
Yes.
aimed to regulate the same kind of conduct, but the court might rule differently, and that may lose the importance of the transformatory objectives of the Constitution.
Yes. Yeah. But I think that the Constitutional Court, in its majority judgment, has laid the path. I think we all have to follow that. I think it's a well-reasoned majority judgment of the Constitutional Court, and I think it has laid down important principles as to how these matters should be approached.
Lastly, it's a different question I've been asking all the candidates. And I'm glad you come from the Supreme Court of Appeal, where your former colleague, Justice Matapo, was, when he made a proposition here during the interviews that he's of the view that we need to collapse or merge the Supreme Court of Appeal with the Concord, because his view is that you work in chambers in the Supreme Court of Appeal. One apex court can benefit from that, and also the additional judges that will come out of that merging. Do you think that could enhance access to justice?
Yes, Minister, I must say, I haven't given that much thought. But if you ask me to give an opinion on that now, I would maintain the structure as it is. I would maintain the Supreme Court of Appeal as it is and the Constitutional Court as it is. Having sat in both courts, I see the benefit of an apex court having the judgments of the second highest court in the land. I've seen that benefit and I've felt that benefit. So I wouldn't collapse any of the two courts. I think it works well so far. It might well be that there needs to be some form of intervention in the Constitutional Court in the manner that it does its work relating to the speediness with which it produces its judgments. But I think the present setup with the Supreme Court of Appeal and the Constitutional Court maintaining their separate entities, I would maintain that for now.
Thank you, CJ.
Thank you, Minister. Justice Molo.
Thank you, Chief Justice. Good morning, Justice. Justice Makgoka.
Good morning, President Molemela.
Yes, JP Mlambo was whispering next to me here, so he disturbed me. I'm sorry about that.
No problem at all.
Yes, how are you?
I'm well, my sister. How are you?
I'm well too. Thank you very much. Just on that last point, following up on the minister's question, I think it's something that is now common knowledge. It's in the public domain that the caseload or the workload of the Constitutional Court has increased tremendously ever since 2013 when the jurisdiction was amended to make it a court of general jurisdiction. You agree?
I fully agree, yes.
Yes, and it would seem that that in itself has had an impact on the handing down of its judgments. Would you agree too?
Certainly, yes.
Yes, so this question that I'm posing to you doesn't really have a wrong or right answer. I'm just trying to explore solutions to the problem that is existing at that court at the moment. A suggestion has been made that the court could improve its efficiency if it worked in panels. I'm sure you'd agree with that as well.
I fully agree.
Yes, yes. And that would require a constitutional amendment, obviously. Yes. And in making that proposal, a comparison has been made between the Constitutional Court and several other courts in other jurisdictions. And so there are courts in other jurisdictions which have a higher judges' complement than the Constitutional Court. I think there's a court somewhere that has a complement of 16 judges in its highest court. So what would your comment be in relation to a suggestion that increasing the current complement of the judges of the Constitutional Court could also alleviate the problems that it is experiencing at this moment?
Yes. I would agree with that, but also how it goes about doing its work. The frustration that I had, if I could put it as such, was how long it takes to give out an order whether a matter should be heard in that court or not. Coming from the Supreme Court of Appeal, where these applications are dealt swiftly, it created a lot of frustration in me. You'd know that in our court, on a Tuesday, an application for leave to appeal would land on my desk. I leave out everything. I deal with that. At the latest by Friday, the order should be out. If by Friday the order is not out, there's something wrong. In the Constitutional Court, it takes months and months and months, sometimes up to 7 months, to produce that order that says, we are not going to hear this. And the public out there does not know what goes into it. What goes into it is a lot of work. Basically, it's a judgment. A colleague would produce a memorandum and other colleagues would have a look at it. They would they would have their say, and because it is a court which sits en banc, all at least 8 colleagues, or if the full complement is reached, all 11 colleagues should ultimately agree with the outcome. But what the public sees out there is the order, that little order, that this does not concern our jurisdiction. And it attracts a question: why did it take so long for you to tell me that this matter does not engage the jurisdiction of the Constitutional Court? Yes, I agree that the number of judges can be increased, but how they go about doing, especially on applications for leave to appeal, should be looked into, because that also impacts on the time that is left for judges to concentrate on their core function of judgment writing, research, and scholarship.
Yes, thank you very much. That was just a follow-up. I'm now asking the question. The jurisdiction of the Constitutional Court is set out in Section 167(3) of the Constitution.
Yes.
At first blush, it may seem as if it's something that is easy to determine. However, we have seen several judgments of the Constitutional Court where there were divergent views from the very judges of that court as to whether a matter raised constitutional issues or whether it raised arguable points of law of general public importance. So what would you personally take into account in relation to establishing whether the jurisdiction of that court has been engaged?
Look, I think in every case, it's a case-by-case determination, sometimes a value judgment of what is right. And so it is never an easy exercise, especially if it is clearly not a constitutional matter. Then you have to take into account those other factors. It's never an easy situation. It's a case-by-case determination.
But what would you regard as important factors, for example, in relation to establishing whether a matter raises an arguable point of law of general importance, for example?
Well, obviously, it's the question is, does this raise a matter of importance? Does it affect our jurisprudence? Does it have wider implications beyond the parties? So those are some of the considerations that you want to put into the picture.
Yes, thank you. Section 172 of the Constitution provides that where either the High Court or the Supreme Court of Appeal has declared legislation invalid or conduct invalid, that order must be confirmed by the Constitutional Court. What do you think is the rationale behind that?
Well, the Constitutional Court, by design, is the apex court in the country, and you would want to have assurance that the best legal minds in the country have confirmed what the High Court would have said. I think the framers of the Constitution were careful that it should not end at the level of the High Court or at the level of the Supreme Court of Appeal. It should be the apex court in the country that says that, because it's got wide implications. Some of the declarations of invalidity in the High Court, in the Supreme Court of Appeal, got wide implications for the country. I mean, if you just look at the cases that went to the Constitutional Court coming from the High Court, very, very important matters. So you would want that to be confirmed by the highest court in the land.
Yes, thank you. My last question, CJ. You have been a justice of the Supreme Court of Appeal for 5 years now, and you are also a presider. Would it be fair to say that you have by now been exposed to a variety of cases touching on literally every branch of the law?
Yes, I think I've written extensively on most aspects of the law.
Where you did not write, you were part of the panel.
Of course, I mean, you know that as a presiding judge in a particular panel, your duty is to guide, to make sure that the law is properly stated, the jurisprudence is kept compact. So, yes.
So if appointed to the Constitutional Court, you would be able to hit the ground running, to use common parlance.
I think so.
Thank you, Justice Makgoka.
Thanks, my sister.
Thank you, Judge President Mlambo.
Nkwe, Kgotso,
Mapisa.
I was disappointed you didn't address your president as Minna Tsipi. But anyway,
I was tempted.
Nkwe, when you acted in the Concord, would I be correct that you would have been involved in leave to appeals or petitions in matters which went to the SCA and those petitions were dismissed?
Yes.
Right. And I think that's what...
I'm sorry, what was the answer?
He said yes.
Yes, okay.
Yes.
I think both the CJ and your president dealt with how both courts deal with their work. The SCA way of doing work is lauded as more efficient because it's in panels in terms of petitions, in panels in terms of hearings. I'm not sure I understood your question about the panel's solution for the Concord. Did you suggest in
Yes.
both respects?
Yes.
Petitions and hearings?
Yes. There are really matters in the Constitutional Court that I felt, look, this could be done by at most 5 colleagues. You don't need the whole panel of 11 or 8 judges.
What would you say to the view that says, because the SCA has that advantage of panels in terms of both aspects, that it would create the necessary buffer that ensures that what goes to the CC coming from the SCA will be something that engages the jurisdiction of the CC. That is, a view would have been expressed by the SCA.
Yeah,
You agree with that?
I agree with that.
Yeah. And the reason I'm asking that is, it appears to me that it would be more advantageous to the CC to reduce its appetite of hearing matters where the SCA hasn't expressed a view. You agree with me?
Well, look, remember there is a constitutional provision for direct access. Some of the matters that ultimately I had in the Constitutional Court, they've not gone via the SCA, gone from the High Court straight to the Constitutional Court.
I'm aware of that. I'm not talking about those matters.
Yes.
Yeah, there's not many of them. And in any way, the CC's approach to those matters is far more strict.
Okay.
Yes.
So you're talking about matters that
Yes.
went through the SCA system.
Yeah.
Yes. To that extent, I agree that the SCA would create what you call the buffer.
Yeah.
Yes.
Okay. Because the paneling solution for the CC is something that would go against the grain of some apex courts internationally, because they all sit in bank.
Yes.
But nevertheless, you support the paneling solution for hearings as well.
Yes.
Okay. Thank you, CJ.
Thank you. Those were the only hands I had, and I see there is one now, Commissioner Ngubatobi.
Good morning, Justice Makgoka.
Good morning, Toby SC.
Yes, I just want to ask two questions. I mean, one is always tempted to go back to this question about what kind of a constitutional court we have in mind before getting bogged down to the logistics of making it possible. Because when the current frame of the Constitution was designed, the country really wanted a special court to deal with 350 years of apartheid colonialism, which had displaced a legal system based on dignity and imposed a European system which is founded on racism and dispossession. And the idea was, well, let's get a special court that will sit and bank. And its primary function would be to develop a new jurisprudence for a new country.
Of course, yes.
Now, whenever we talk about empaneling this and empaneling that, I wonder whether we are not forgetting why the Constitutional Court was established in the first place. Now, if I can ask you then, the first of my two questions is whether you think the Constitution embeds within it a vision of the economy. I mean, we always talk about social justice, but it seems to me after 30 years of trial and error, there is no social justice in South Africa, despite the Constitution and the Constitutional Court. And one could say it's because the Constitutional Court is not doing enough to translate the vision of the Constitution into practice. Or one could say it's because the executive is not doing enough, or because the parliament is not doing enough. This ball of the absence of social justice keeps getting pushed around. But you are applying to be a judge of the Constitutional Court, so you should answer for the Constitutional Court. Do you think there is a vision of the economy in the Constitution itself, that the economy of South Africa should be a transformed economy?
In the Constitution?
Yes. Well, that's the only weapon you have as a judge, is the Constitution. But do you think it embeds a vision of economic transformation?
Well, yes, it must.
Yes, just expand on that. How? I mean, one of the ways of looking at the Constitution is that it's a series of rights.
Yes.
In the Bill of Rights. But it does not itself require economic transformation, and that's something that must happen, in a sense, outside of the Constitution.
Yes.
But if you are going to say, I actually want the economy to transform, the stock exchange to transform, is that sourced in the Constitution or elsewhere? The reason I ask this is because I've got this problem that the common law of contract and property is taking place in parallel to the Constitution.
Yes. Well, the Constitution does not explicitly provide for the economic solution that you speak about, but the Constitution provides for justiciable Bill of Rights, especially on socio-economic rights, and that's the closest you can get to the economy, socio-economic rights. I don't know to what extent courts and judges in particular can do to uplift the economy of the country, but to the extent that matters can come to the Constitutional Court, where rights are involved, rights are violated, I'm sure that the Constitutional Court will, as it has done, would vindicate those rights.
No, I don't disagree with you that the Constitution contains a vision for the Bill of Rights. It's there, it's spelled out. In fact, that was the big demand of the struggle.
Yes.
I'm asking you whether the Constitution contains also a vision for economic transformation so that we can transform the stock exchange through the law.
Well, as I said, I don't think there is any explicit reference in the Constitution to that. It might be implicit if you read the Constitution widely as a vehicle to reconstruct South Africa, but there's no implicit or express provision in the Constitution for that.
Yes, but what do you think?
Well, Commissioner Moeto, he has told you what he thinks.
No.
He thinks expressly there is nothing, but he thinks maybe somebody can imply. I think that's the gist of his answer. I don't know if you understood this. You can follow up. I'm just saying he seems to have expressed what he thinks.
No, well, okay. I mean, I don't know, Justice Makgoka. I mean, this is not a trick question. It's to really try and engage with why do we have so much inequality after all of these marvelous legal reforms? Why do we have so much poverty? Is it because there is, in the Constitution itself, a poverty of dealing with the economic question? Or is it because we're not doing enough to realize the economic vision in the Constitution? And if it is there, you've said, okay, well, it's not expressed, but are you saying it is implied? And it's implied in the socio-economic rights provisions?
Yes, I mean, as to whether we have done enough, we might have to look to the executive. Might have to look to the executive as to whether the executive has done enough to marshal all the resources in the country to make sure that this economic emancipation is realized.
Okay, yes. My issue, you're not applying to be in the executive, you're applying to be in the judiciary. I just want to know whether there are any legal tools that we have that we are maybe not using or maybe we can use.
Yeah.
So when you are a judge of the ConCourt, would you have this vision of economic liberation through the Constitution? And if so, where in the Constitution are you going to look?
Yeah, look, I must say I haven't applied my mind to that question, but I'm a product of the liberation struggle. I was part of the liberation struggle in the Black consciousness movement, and that remains the economic empowerment and upliftment of Black people in particular remains at the back of my mind. It worries me, as it worries you, obviously, that after 30 years we haven't moved as speedily as we should have.
Yes, all right. So something you'll think about. Now,
Yes.
the next question relates to the Clicks judgment, not the substance of the judgment. I've read it, but it's the answer you gave when you were first asked about the question, which is you were looking at the impact of the decision by Clicks, particularly on community pharmacists, that it would squeeze them out. Now, the reason I ask is related to my first question. You know, we had a debate when Justice Unterhalter was here about what he referred to as consequentialism in judicial interpretation. So whenever I hear a judge saying, I'm worried about the consequences, it always sounds like they're not worried about the doctrine. They just want to know whether the consequences will be something palatable or not. So where do you fall in those two schools of thought between sort of doctrinal-based adjudication and consequentialist-based adjudication?
Well, look, I've always been a pragmatist. I might straddle between the two schools of thought, but I'm always looking at the consequences. You look at my judgment in the Magidi matter, where about the Marikana legal representation. I had no legal basis effectively to get the injured minors to be assisted by the state. But I had to think consequentially as to what would happen if these people are not represented at that commission. And that's how I came to the conclusion that they should be assisted by the state.
Thank you, Chief Justice. I have now been answered.
Okay, thank you. And there may be two follow-ups. Yes, Minister. Shall we try and limit follow-ups to one question?
Yeah,
Yes, Minister.
Thank you, CJ. My follow-up relates to the first question that you said you have not really applied your mind to. So I'm a bit confused because when I read the Clicks judgment and your answer to me, when you said you started with the Constitution to applied its transformatory effect, particularly on the concentration in the economy, the outmuscling of community pharmacists. It sounds like a transformatory interpretation of the Constitution. So that's why I'm a bit ambivalent to the response you have given to Advocate Mwaidobe. I'm a bit confused. Well, is that not the answer?
I don't know. I think I was dealing with the doctrinal issue as to basically was asking me my legal philosophy. That's how I understood his question. That are you a doctrinal judge or are you a consequential judge? You think about the doctrine.
That one is the second question, Judge Makgoka. The first one relates to when he asked you whether the Constitution has got instruments that you can use to transform the economy.
Yes.
Yes. So I'm asking you because this clique's judgment does reflect that aspect, particularly on the community schemes. The economy is concentrated. It relates to opening up the economy, the health sector, but you did not provide that. So that's why I'm a bit confused.
Yeah, I take your point.
Yeah, so that is my question.
No, thanks. I take your point. Yes. So the clique's judgment is a good example of the answer to advocating by Toby SC. I think that's what you say, and I agree with you.
You're done.
I have a follow-up.
Before I go to Commissioner Pillay, I just wanted to say, notwithstanding that assistance, no marks will be given. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Makgoka.
Good afternoon, Commissioner.
Justice Makgoka, I want to follow up on the second question asked by Commissioner Nkaitobi, and to which you answered that you focus, during your judgments, you focus largely on the consequences of whatever dispute you're arbitrating. May I just ask you this, and I was concerned about this when I was reading your Ndesha judgment. I think that's the matter involving the admission of an attorney who hadn't complied with a requirement of the Act which you found to be peremptory.
Yes.
So you considered the Act, you considered that the requirements of the Act are peremptory in that the applicant has to have done PLT either during articles or immediately after articles.
Yes.
You were faced with an applicant who had done her PLT course before articles.
Yes.
And you were, in that matter, presiding over the admission of the applicant.
Yes.
And notwithstanding the fact that you found that the section of the Admission of Attorneys Act was peremptory, you then still went on to admit the applicant.
Yes.
And you did it through an adoption of a purposive approach to the interpretation of the section.
Yes.
When I read it, this is a 2018 judgment. When I read it, it immediately struck me that you conducted the exercise without considering, for example, separation of powers concerns. Because your ultimate interpretation of the judgment made a marked change to the requirements of the Act. I just wanted you to talk us through that process.
Yes. Let's start with the effect of what would have been had I adopted the Law Society's approach. It would have meant that many black candidate attorneys would not have been admitted, despite the fact that they would have done practical legal training and they would have passed board exam. They would have had to, there would have been a problem with the admission. And that's a situation that I couldn't live with as a judge. It's an old judgment, this was 2018. I can't remember the exact reasoning, but my approach was, despite the peremptory language of the Act, there was a leeway to admit that candidate despite the fact that the sequence was not right, because ultimately what was in issue was the sequence. I could have said to that candidate that day with all the parents and everybody who was there to support her and said, despite the fact that A, you have done practical legal training, B, you have passed the board exam, I can't admit you because the sequence was not right. Majority of black candidate attorneys are not able to get articles without doing practical legal training. Practical legal training gives majority of them the basis to get articles. And that was the basis on which I approached the matter.
And can I just follow up on that last bit, the factual matrix that you took into account?
Yes.
Because obviously this was a standard application for admission by an
Yes.
attorney. You took into account facts around systemic circumstances of black candidates specifically.
Yes.
You don't make a note in your judgment that you're taking judicial notice of that. You don't say where those facts are extracted from in the context of an ordinary admission application. So I just wanted to get a sense of how you dealt with that.
Well, I think those facts are notorious. The fact that most black candidate attorneys struggle with entry into the profession are sufficiently notorious. I didn't have to get any document or empirical evidence about that. I know about that. It is historical and it is well out there. We know about it. It is sufficiently notorious.
Thank you, Chief Justice.
Well, I just want to do a follow-up on that. I didn't get to reading the judgment, but I read what you say in the questionnaire about the judgment, and I was also concerned a little bit about the fact that while the statute only contemplated this training to be taken into account if it's done during articles or after, you concluded that somebody who did the training prior to articles complied with the statute. That seemed a little problematic to me. And I think the separation of powers concern that Commissioner Pillay raises goes to saying there are times where, as a judge, you see what the statute says,
Yes.
and you may see its consequences, that its consequences maybe are undesirable or they are unfair, but nevertheless, you might decide that is something that must be rectified by Parliament. And it's not your role as a judge
Yes.
to rectify that. I think that's what Commissioner Pillay is raising.
I take the point, Chief Justice.
Yes, yes. You know, sometimes a judge reads a statute, sees what has happened in a particular case, and doesn't think that there is a good reason why the position should be as stated in the statute, but decides that I must just indicate that Parliament must consider whether it shouldn't amend. And Parliament can consider that amend if it's persuaded and not amend, or the judge can just point out the challenges and say, I'm not able to come to your assistance. There are situations where interpretation permits. There are situations where interpretation doesn't permit. But one of the things also that concerns me is if you concluded that the statutory provision was peremptory, whether there was room for you to come to their assistance, because I may be wrong, but that seems to suggest that you were saying there was substantial compliance. There was no strict compliance, but maybe you were thinking there was substantial compliance because the training, the candidate attorney had undergone the training.
Yes.
They just happened to do it before. But of course, the legislature might have good reasons why they think it should be done only by people who have started, who are in going through their articles or after.
Yes.
Yeah, but you understand. I'm not saying you are right or wrong, but I'm just saying that there may be those concerns.
Yes.
Yeah.
I take the point, yes. As I said, I haven't read the judgment recently, but I think that's the part that I took, that there was substantial compliance. I think that's what I might have influenced me. Thank you.
Yes, thank you. Commissioner Waitobi.
No, I'm happy to pass this one on, Chief Justice, given that I've already asked 3 questions.
Thank you. Commissioner Lucas.
I will really, for the interest of time, also pass.
Thank you very much. We are doing very well. Commissioner Marumachai.
I have a follow-up. Mine is a follow-up to this line.
Oh, I'm sorry. I was going to put you later.
Yeah.
Okay, follow up.
Just concerned about your answer about consequentialism and doctrinal philosophy. When you sit on the Constitutional Court, you're making law for everyone for all time. What do you do if, on the facts of that particular case, the just outcome would create a precedent that A, is not legally sound, and B, might create havoc in other ways? How do you then balance, the old adage that hard cases make bad law, right? How do you balance trying to find the right consequences of a case with the impact of that forever and a day? That was the context of the debate with Justice Unterhalter. I think it was apropos the Eskom Vaal River development, where he may be wrong or right. That is not my point. His minority judgment was saying that I realize my judgment would result in hardship for people, but at law we cannot do anything else. It would be wrong, and we would also open the floodgates in a manner that would put Eskom on its knees due to incapacity. So I'm less interested in a debate on that judgment because I think it's highly debatable. But the principle that I'm articulating.
Yes. I think you are correct. We should try to stay as close as possible to the law. And majority of cases lend themselves to that. There will always be difficult cases where the law is not that clear. The law does not provide for simple answers. And those cases would be few and in between. And those are the difficult cases. But I agree we should stay as close as possible to the law. We should be guided by the law in all what we do. But as lawyers, as judges, we must also think about the consequences of our judgments on society.
So what do you do when the consequences suggest one thing, but the precedent suggests another?
Well, look, I mean, in the Constitutional Court, that's an apex court. It can develop it can develop the law in a particular direction. It could well be that in certain cases, the consequence must be unpalatable, like you mentioned in the ESCOM matter. But if that's what the law directs us to do, that's what we should do.
Thank you. Thank you, Chief Justice.
Thank you very much. And maybe, Justice Makgoka, maybe sometimes we might wish to say, well, these consequences are a result of a choice made by the legislature.
Yes.
So we shouldn't feel bad because we are not responsible.
Exactly, Chief Justice.
Okay, all right. The minister, the executive is laughing. Commissioner Marmoha.
Thank you very much, Chief Justice. Good afternoon, Judge Makgoka. This side.
Oh, hey, Prof.
No, thank you very much. I initially had two questions for you, but from your interaction with President Molimela, the third question arose, and I want to start with that question. There have been a number of decisions from the Constitutional Court which have dealt with the issue of this general jurisdiction. Not desirably, but touching on it, right? And I think as the people of South Africa, we want to make sure that when the judge goes to that court, they are fully engaged with the jurisdictional elements of the court. And I want to give you a chance to really answer that question, because I thought it was an important question, which I did not think that you really answered it. Because there's not really been a test or criteria that has been designed for us to really know what this thing actually means. When you are sitting as one of those judges, when memos are being circulated and the question is asked, does this, oh, well, everyone is clear that the Constitution is, the constitutional jurisdiction is not engaged. Then the general jurisdiction, what are you actually looking for to agree with any colleague who says it has been engaged or it has not been engaged? What exactly are you looking into?
As I said, it's a case-by-case situation. Firstly, from my own personal perspective, does it relate to our jurisprudence? Would this case have an impact on our jurisprudence, on any aspect of our jurisprudence? Two, does this case have wider implications for the country or the community beyond the parties themselves? Thirdly, does it appear that the judgment of the Supreme Court of Appeal needs to be rectified? Because sometimes the judgment of the Supreme Court of Appeal is clearly wrong, but as the Constitutional Court, we might say, well, this is not the case for us to pronounce ourselves on this matter. But taking into account all those, it might come to, well, it is wrong, and in any event, it's got wider implications. It impacts on the jurisprudence. We need to clarify this aspect of our jurisprudence.
Thank you very much, Judge Makgoka. The second question that I have, last year I had an occasion to come across an issue where these contracts, these credit sale agreements, where people sign them and they are buying cars and all those kind of things, and you are bound to the contract, and once you are bound to it, it's a pro forma form, you are just signing it, and later on there's a default judgment against you, you have to pay. And it raises an important question. There has been a debate in South Africa with relation to the contract and how the Constitution impacts contract law in South Africa. And we have seen decisions where the judges of the Supreme Court of Appeal have not been particularly happy with the jurisprudence that is coming out from the Constitutional Court. Even some of them writing extrajudicially to express their opinions on the role of what we reasonably agree to be abstract concepts like fairness, Ubuntu, and all those kind in relation to the contract. I just want to know, as a judge who's moving from that court to that other court, where do you stand in relation to the debate as to what should be the role of the Constitution in contract law in South Africa?
Well, contract law is not immune from the constitutional scheme. Contract law, like all other law, yields to the Constitution. The Constitutional Court has laid down, I think, Buckhazen case, Botha versus Rich. They've laid down very, very useful guidelines as to how this should be approached. And I think that's the jurisprudential basis on which matters of choice, factors for Vanta should be approached.
Okay, for the sake of time, let me leave it there. Thank you very much, Judge Makgoka.
I'm sorry I was not helpful to you either. Please.
No, you gave me your view. I wanted your view. There's nothing wrong with that.
Yeah.
Thank you, Judge Makgoka.
Thank you.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Just one short question. Good afternoon, Judge Makgoka.
Good afternoon.
In 2018, when President Maya asked you a question about gender representativity in the SCA, you were noble enough to say that if 3 female black women are recommended, you will step down.
Yes.
And that was very noble of you. I'd just like to know, since then, have you done anything to contribute to gender transformation agenda within your field?
Commissioner Singh, that has been an ongoing project of mine. I have been involved in SAJE, in training of aspirant female judges. Last year, I did 2 sessions with them. There's a group that is under the tutelage of the former DJP of Gauteng, Mojapelo, retired Deputy Judge President Mojapelo. It's a group of women that have journeyed with him for almost 6 months. So I was part of the people who assisted that group. I lectured to them on several aspects of judgeship. In my own court, I've made sure that those acting colleagues of ours that came to our court got the necessary assistance, got the necessary empowerment, and yes, it's an ongoing project.
Thank you very much. You've lived up to what you believe in. Thank you, Chief Justice.
Thank you very much. Commissioner Pillay, or are you covered already?
I'm covered, thank you.
Thank you very much. Commissioners on the virtual platform, I didn't see any hand. I therefore think that we have come to the end of this interview. Thank you very much, Justice Makgoka, for availing yourself once again. You are now excused.
Thank you, Chief Justice. Thank you.